Alright, ladies and gentlemen, welcome to the criminal law process. In the last lesson, we talked about criminal law itself and kind of getting into types of crime, types of law, and also the two sides in a criminal case, so the prosecutor versus the defendant, so someone who is trying to put someone in jail versus someone who is trying to defend themselves. And today we're going to walk you through the process of how you go from someone who has allegedly committed a crime to how they get sentenced and all the steps in between. So what is the criminal law process overall? You don't have to write this down. It's how a case goes from a broken law all the way to your enforced consequences. So how do we go from the legislative branch laying down a law to the executive branch enforcing and then to the judicial branch interpreting law? So how do we move through that process? Alright, so a little bit of review of Unit 6 before we start. Please look for these terms in the margin and fill them in. You have already heard of them before and you've already seen them, but just so we refresh your brain and get your brain in civics mode, let's go ahead and write this down. So a plaintiff versus a defendant, these are the two sides of a civil case. The plaintiff is the one who is making the complaint. They are the people who are upset. They are the ones who are suing. So they're on offense, all right? And of course the defendant is on defense. They are the person who's been accused of the crime or of breaking a contract. Now, a prosecutor, on the other hand, is for criminal law, and a prosecutor is someone who represents the government. Please make sure that you are abbreviating GOV''T. All right, this person is typically the district attorney or the assistant district attorney for whatever region you live in or whatever district you live in. So we just recently in Pitt County had an election to elect a new district attorney. All right. If you are on the defense, again, you are on defense. A prosecutor is on offense here in the courtroom. All right, and of course the defense represents the defendant, so the person who has been accused of the crime. All right, so all their alleged charges. It sounds simple. We're going to move from enforcing the consequences to interpreting them. But it might not be as simple as you think. There are 8 major steps in the process, and there are multiple little baby miniature steps, but we're not going to talk about those because hopefully it won't happen to you. All right, the first one is probable cause. So this is going to have to fit in those small boxes on your note sheet. So number 1 is probable cause. You were starting at the top left-hand corner, and as you follow the arrows in the presentation, you move forward. All right, so probable cause. Oh, man. There we go. Probable cause means there is a strong chance that someone has broken a law. However, we know from our notes from our previous lesson that you are innocent until you are proven guilty. So people can't just assume that you are guilty. All right, so if you're having trouble fitting everything in the box, you can just write the top bullet. There's a strong chance that someone has broken the law. All right, so it sounds slightly illegal. All right, the next one, number 2, we are moving to the right-hand box. All right, number 2 is arrest. All right, so once you have probable cause, you can't just arrest somebody off the street with no reason whatsoever. All right, does this happen nowadays? Yes, it does. However, if we are going to get real about it, our judicial system is not supposed to work in that fashion. All right, you are supposed to arrest someone once you have probable cause, and this comes in the form of a warrant. All right. So the police will get a warrant, they will get a judge to sign it, and the suspect will be arrested and informed of their charges. And I hope you remember what rights these are called because there's a question coming up. Alright, and in the third part of this process, once they have been read their Miranda rights and they have moved on about their business, they are taken to booking. Alright, so a lot of people will call this central booking. So if you've seen a Law & Order episode or a Law & Order SVU episode that talks about central booking and being processed in a jail cell, that's what that means, because jail and prison are 2 different things. All right, so you got to fit both of these bullets in the booking section. If you are struggling to fit these in, if you would like to write these steps down on a separate sheet of paper and staple them to your note sheet, I will not be offended. Okay, so if you need some more space, please feel free to take these on your own paper. But we do provide the graphic organizer for you. So now in central booking, the suspect is officially taken into police custody and officially charged with a crime. You are charged with a crime now. That does not mean that you are convicted. All right, that happens way, way further down the process. All right, and now you are no longer known as a suspect. You are now called a defendant. All right, so after this point in time, you have been sitting in a jail cell waiting on somebody to inform you of your charges, and now you are known as a defendant. This is the point where you get your fingerprints taken, mug shots, you get a lovely orange jumper property of the Pitt County Detention Center, you get some nice fake cats and some cool bracelets to wear, and you head on down to Cell Block D. And then number 4 is what's called the preliminary hearing. So this is kind of the point after a central booking where it gets a little fuzzy and a lot of our steps kind of sound similar and seem like they accomplish the same task, but they do not. All right, now in a preliminary hearing, the defendant, because remember, you're not a suspect anymore. All right, now we have a defendant. Let's say that we've got an example person that let's say we got Joe Dirt has stolen all the good snacks from Sheetz, and they have a video of someone who matches Joe Dirt's description, stealing all the good snacks from Sheetz. All right, so now Joe Dirt is the defendant because he has to defend himself, and he is considered, again, to be innocent until proven guilty. He's brought before a judge and has to learn more about the charges against them. A judge has to physically tell you what your charges are, and that is called a writ of habeas corpus. And then the judge sets your bail requirements based on the case and the defendant. So if Joe Dirt has never had another prior arrest made in his lifetime, Joe Dirt is going to get the smaller amount of bail that is recommended for the crime. So again, according to this amendment, you cannot have any cruel or unusual punishment or any excessive bails or fines. I hope you remember because there's a question coming up. So according to the 8th Amendment, hopefully you got that one right, all right, the judge sets your bail requirements. If you just stole a pack of gum from Sheetz, you do not need to be set at $1 million bail. That is not how it works. All right, so whatever you do has to fit the crime. So now let's say that this is Joe Dirt's like 7th offense, and he's got a couple felonies on his rap sheet. His bail might be a little higher than someone who has broken the law for the first time. Okay, this is your preliminary hearing. This is just where this is the little baby part in Law and Order where they come in and the judge asks whether or not the person is a flight risk. So if they get on a plane, is there going to be an issue? They say bail will be set at $2 million. They slam the little gavel down. You move on about your business, go on back to Cell Block D. All right, so a little side note here. Bail is money to ensure the defendant returns to court. It has absolutely nothing to do with your verdict. All right, so if you're guilty, you still get your bail money back. If you are not guilty, you still get your bail money back. All right, if you pay a judge $1,500 and you don't show up and you get an FTA, a failure to appear on your rap sheet, that $1,500, congratulations, you've just lost it, and it has been turned over to that county's prison system for them to use in whichever way that they see fit. Okay, so that is bail. It is money that is to ensure that you come back to court. So if your tail comes back into court and you are dressed in business casual clothing, you get your bail money back regardless of the verdict that is laid down for you. Okay, so we move on to step number 5 out of 8. We're getting closer to the trial here, getting a little closer to guilty or not guilty. The next one is indictment. This C in here is silent. Indictment. All right, an indictment is a verb. All right, an indictment gets done by a grand jury. And I hope you remember which amendment gives you the right to a grand jury because there's a question coming up. All right, now, a grand jury decides if there is enough evidence to take you to trial. When you think of a jury, you're probably thinking of the 12 people who sit on one side of the courtroom and lay down a verdict for someone and say, we find the defendant guilty, we find the defendant not guilty, or whatever they decide to do. Okay? A grand jury is very different, but it is also equally as important as the small jury that lays down a verdict. Okay, so a grand jury is typically like 20 to 25 people, depending on the case. They all get into a room. The prosecution, so the offense team who is trying to put you in prison or put our friend Joe Dirt in prison, they bring all the evidence against that defendant and all the witnesses that they have access to at that point in time. They bring them in front of the grand jury. They present them the evidence, and then the grand jury decides, yes, there is enough evidence to take this person to trial, or no, there is not. All right, there is no sense in us wasting 12 people's life for 2 months on this long, drawn-out trial if there's not enough evidence to even go there in the first place. All right, so number 5 is indictment. All right, so a grand jury, you stand in front of a grand jury, and the grand jury will put their decision down to a judge. I'm going to skip this. All right, number 6 is arraignment. Arraignment. All right, so now that you have, let's say that the jury decides to move to indict you. That means that they said, yes, there is enough evidence to take you to trial. You move on about your business. Do not pass go. Do not collect $200. All right, so the defendant is now informed of the charges against you again, and this is the part where they say, how do you plead? And you say, not guilty, Your Honor, or guilty, Your Honor, or no contest. No contest is kind of strange. It's weird. Don't do that. All right, so the goal here, you plead either guilty or not guilty, and it is the job of the prosecutor and the defense to prove this at the trial, either way. Okay? He's guilty. Everybody knows. All right, so a side note from last time. All right, a writ of habeas corpus means that you must inform the person of the charges. This side note you will find on the left-hand side of your margin on your note sheet. All right, and another side note, there's a whole bunch of side notes we got to talk about here because this will come into play later on when we work through our own mock trial. So a plea deal, let's say that you decide that you're going to plead guilty. That means that you don't have to go to trial. Nobody has to be on a jury. You do not have to pull 12 people out of their daily life to see whether or not you did a crime. If you decide to save everybody that much time and hassle and effort, sometimes, let's say that Joe Dirt, our friend here, his original charges are grand larceny, and that's going to wind him up in prison for 5 to 8 years. Let's say that he pleads guilty. If he pleads guilty, he might ask them to knock it down to a misdemeanor, and only serve, I don't know, a couple years probation. All right, so since he pled guilty, he pleads guilty to a lesser charge in order to get a lesser punishment. All right, so let's say that we're talking about like a murder case. Instead of, if people know that you did it, all right, so instead of pleading not guilty and dragging it all out for a couple months, you would plead guilty, but you'd plead guilty to like second-degree murder or to manslaughter. So instead of 25 to life, you only have to serve like 15 to 20 years. Okay, it saves court time. It saves you probably time in prison. Okay, number 7 is a trial. All right, this is the part that you're thinking about when they're in the courtroom. There's lawyers arguing. There are people in the courtroom who are upset. Order in the court. Order in the court. All right, the judge slamming the gavel down and people are upset. All right, so you have to pick a jury. It's a long process. You open up with your statements. You present your cases. You ask questions. You close up with statements, and then you issue a verdict. All right, the jury that is here is the one that you're thinking of in your mind. They're the petite jury, or the small one. All right, there are 12 people, and they reach a verdict. And I'm going to put that video in a side note coming up. All right, and then number 8, our very last part is sentencing. All right, so let's say that you are convicted. All right, that means that you have been found guilty. And so since you as the defendant, not you necessarily, but if a person, let's say Joe Dirt, our defendant here, has been found guilty, his sentencing is based on what's called the penal code. All right, and it's just basically a long list of crimes and their matching punishments. All right, so there are 2 kinds of sentencing. One of them is indeterminate. It's got a maximum and a minimum. So like 25 to life, 15 to 20, 8 to 10, whatever it might be, it has a maximum and a minimum, and the judge and the jury together can decide. All right, typically the judge will lay this down, though. And then mandatory is a set punishment. There is no wiggle room. You cannot get out on good behavior. You cannot serve a lesser time. All right, so like an example of this would be like armed carjacking. All right, it's 10 years. Doesn't matter what time, what offense it is what it is. Okay? Here's another side note. You guys got this. And then one last one about loss of life and the differences between first, second, and third degree murder and manslaughter. All right, and this has been the criminal law process.